The Noose Tightens-Rumsfeld Ashcroft and other top Bush officials could soon face legal jeopardy, by Jonathan Tepperman, December 19, 2008. From Newsweek web exclusive. If you go to newsweek.com/ID/176044. But I'm actually reading this from Information Clearinghouse. World News, its headline just says, World News Daily, Information Clearinghouse, news you won't find on CNN or Fox News. And I'll just read this article out. I'll put the link up on your right-hand side underneath my channel. Thank you, White Knights. You'll see more info. You can click on that. That will expand out, and you'll see the link for this page if you would rather read it yourself than listen to me. That's fine. I'm just trying to reveal this information, put this information out there in another way. Now, the United States, the article goes, the United States, like many countries, has a bad habit of committing wartime excesses and an even worse record of accounting for them afterward. But a remarkable string of recent events suggests that may finally be changing, and that top Bush administration officials could soon face legal jeopardy for prisoner abuse committed under their watch in the war on terror. In early December, in a highly unusual move, a federal court in New York agreed to rehear a lawsuit against former Attorney General John Ashcroft, brought by a Canadian citizen, Maher Arrar. Arrar was a victim of the administration's extraordinary rendition program. He was seized by US officials in 2002 while in transit through Kennedy Airport and deported to Syria, where he was tortured. Then, on December 15, the Supreme Court revived a lawsuit against Donald Rumsfeld by 4 Guantanamo detainees alleging abuse there. A reminder that the court, unlike the White House, will extend constitutional protections to foreigners at Gitmo. Finally, in the same week, the Senate Armed Service Committee, led by Carl Levin and John McCain, released a blistering report specifically blaming key administration figures for prisoner mistreatment and interrogation techniques that broke the law. The bipartisan report reads like a brief for the prosecution, calling, for example, Rumsfeld's behavior a direct cause of abuse. Analysts say it gives a green light to prosecutors and supplies them with political cover and factual ammunition. Administration officials, with a few exceptions, deny wrongdoing. Vice President Dick Cheney says there was nothing improper with US interrogation techniques. We don't do torture, he repeated in an ABC interview on December 15. The government blamed the worst abuses, such as those at Abu Ghraib, on a few bad apples. High-level charges, if they come, would be a first in US history. Traditionally, we've caught some poor bastard down low and not gone up the chain, says Bert Newborn, a constitutional expert and Supreme Court lawyer at NYU. Prosecutions may well be forestalled if Bush issues a blanket pardon in his final days, as Newborn and many other experts now expect. Some see Cheney's recent defiant-sounding admission of his own role in approving waterboarding as an attempt to force Bush's hand. Constitutionally, Bush could pardon everyone involved in formulating and executing the administration's interrogation techniques without providing specifics or naming names. And the pardon could apply to himself. Such a step, however, would seem like an admission of guilt and thus be politically awkward. Even if Bush takes it, civil suits for monetary damages could still proceed. Such cases, though hard to win, are proliferating. Yet most legal scholars argue that a civil suit would not be the best approach here. Newborn calls it an excessively lawyer-centric strategy and says judges are extremely reluctant to award damages in such cases. Conservative legal experts like David Rifkin, who served in the Reagan and first Bush administrations, argue that no accounting is necessary, since the worst interrogation techniques like waterboarding have already been abandoned and Obama is expected to make further changes. A growing group of advocates are now instead calling for a South African-style Truth and Reconciliation Commission. Kenneth Roth, Executive Director of Human Rights Watch, says that although we know what went on, knowledge and a change in practices are not sufficient. There must be acknowledgement and repudiation as well. He favours the creation of a non-partisan commission of inquiry with a professional staff and subpoena power, calling it the only way to definitively repudiate this ugly chapter in US history. But for those interested in tougher sanctions, one other possibility looms. Michael Ratner, President of the Center for Constitutional Rights and author of The Trial of Donald Rumsfeld, points out that over 20 countries now have universal jurisdiction laws that would allow them to indict US officials for torture if America doesn't do it itself. A few such cases were attempted in recent years but were dropped, purportedly under US pressure. Now the Obama administration may be less likely to stand in their way. Full stop. This doesn't mean it will extradite Cheney and co. to stand trial abroad. But at the very least, the threat of such suits could soon force Bush aides to think twice before buying plane tickets. The world is getting smaller for these guys, says Ratner, and they'll have to check with their lawyers very carefully before they travel. Jail time, it isn't, but it may be some justice nonetheless. If you want more on topics like this, I mean, that's my specialty. Just go to my channel at youtube.com/thankyouwhite knights.